Step number 6 is to distribute the net assets. This is where all your hard work has been done, and now you get to write checks either to yourself or others, or whatever the situation may be. Wherever the decedent said they want the money to go, and there's been a probate or there's a trust administration, now you've done your job. You either have an estate account that was set up through the probate where you put all the money, paid all the expenses, or if it was a trust, there's already a trust account set up which had all the money, and then you paid all the expenses, and now you get to distribute out the assets. We recommend that when you do that, before you actually give that money to the beneficiaries, make sure you receive from them a receipt where they acknowledge that if their amount is going to be $50,000, that's what they're getting. And they will sign a receipt that says that they have received their $50,000. Why? So that they don't come back later and say, oh, no, I didn't get everything that I should have gotten. So distributing the net assets of the estate, protecting yourself as the executor or the trustee to make sure that everyone says you distributed what you should have and you've done your job well. Next step number 7, close the estate. Closing the estate in a probate in Washington typically involves filing those receipts I just talked about, filing a declaration of completion, filing a declaration of review of ascertainable creditors. And so those are the fundamental documents. Those are filed with the court, and that brings the probate to a close. It's fairly simple. If there was a trust that you were administering, not a probate, then the question about how do you bring this to a close depends on what the trust said. The trust may have said that when you, as successor trustee, distribute everything out, that your work is done, the trust has ended. And again, with a trust administration, you're definitely going to want to get those same receipts that I mentioned. Sometimes, though, trusts are set up to continue on or to divide, or the initial trust now divides and becomes an irrevocable trust, maybe for the surviving spouse, or it can be a trust that divides that there's 3 kids and all the 3 kids get to have their own trust, for example. They can be their own trustees, or maybe you as a successor trustee are trustee for their trust. So bringing to a close the estate administration on a revocable living trust may not be quite as clean cut as in a probate. It all depends on how that trust was set up, that initial trust, and what it says happens after the death of that the initial person, the grantor, once they die. So that's all a lot of detail that has to be looked at by the trust itself, in the trust itself. Other things to think about. I've covered the 7 steps to settling an estate. Number 1 being who's responsible. Number 2, what help do you need? Number 3, is there going to be a probate? Or 4, no probate. It's either automatic or a trust administration or a small estate affidavit. Number 5, gathering the assets of the estate and paying the expenses. 6, distributing out the net assets. And number 7, bringing it to a close. Those are the 7 steps to settling the estate. Other things that I think it's really important for you to think about. Again, this is a broad overview. We're going to be providing you the 6 essential steps to do-it-yourself probate to give you a lot more information. But other things that I want you to think about is Being organized. Now, if you're the person settling the estate, you have to be pretty darn organized for sure. And your job is way easier if the person who passed away was organized, that they did an estate plan so that there's clear direction for you, that you know what their list of assets are, that there isn't, this ambiguity that these assets you don't know about, you don't know what to do about. One of the things is when people do a will, there's often what's called a personal property list. Maybe you won't be surprised to hear this, but sometimes it's the personal property that causes more problems than anything else. The lamp that everybody wanted, or the whatever. So on a personal property list, if that has been completed, then the person who passed away clearly said, my lamp goes to Susie. And if Susie doesn't want it, then it goes to Jimmy. Great. They can't fight over it because the person who passed away put it in their property list. Property list should be signed, dated, and kept with the will. Unlike most estate planning documents, that personal property list actually doesn't even need to be notarized or witnessed, and it can be changed at any time by the person who creates that list.